Morning, everybody. I'm Siobhan Coonaghan, I'm Director of Research here in the Law Reform Commission, formerly of the Bar of Ireland. And I'm really delighted to welcome you all here this morning, and it's a great turnout. Unfortunately, Mr. Justice Clarke is missing in action, but I hope he'll show up soon. The project that we have been working on, this consultation paper, has been a slow burner, really. It started a long time ago, and it's, I suppose, something that has recently come to a lot of public attention, and there's been a lot of discussion about it. So the consultation paper is very timely, really, but we probably could have done with it at an earlier stage. But it turns out it's a huge topic. So really, we are looking at the development of these specialist bodies to adjudicate on very specific areas of law and to bring expertise to bear in those areas of law. And of course, apart from bringing their expertise to bear, those organisations also provide the state with a great service of expeditious decision-making at a lower cost than the courts. And it allows the court system to function, or at least in the past allowed the court system to function at a different level of decision-making. It freed up, if you like, the judicial resources for a certain level of decision that had to be made. So we owe those specialist bodies a great debt of gratitude in many ways. But over the years, more and more bodies have been created, and the ad hoc development has resulted in bodies having not just a variety of powers, but different iterations of the same power. And that has, over the years, led to difficulties and lack of consistency, and maybe a slightly incoherent system, which is difficult for navigation, difficult for members of the public or the people to navigate, difficult for the representatives, the legal and the union representatives to navigate, and difficult for the adjudicators. Sometimes the adjudicator sits on two different bodies, might find themselves with a different variety of the same power or totally different powers depending on the body they're sitting on. And so we were considering whether there might be an advantage to some sort of standardization, maybe to reducing kind of the isolation that the bodies have, suffered a little bit from. And we wondered whether we could standardize the powers, but still allow for the variation that's really required to allow an expert body bring its own expertise to bear in its own bespoke area. And that actually is a really interesting confluence of issues, if you like. At least I think I know I'm a nerd, but I think it's a very interesting confluence of topics. And obviously, how do we do it? How do we do that without throwing the baby out with the bathwater, without losing all of the advantages of the specialist bodies and to a kind of a rigid structure that isn't the aim of the game? And so we need the input from the specialist bodies to see if something can be achieved in relation to that. And obviously, in a project like that, where you're talking about a standardization, the second aspect of our project, which is judicial oversight, becomes very key. And it is interesting that at this time, the government have recently published the scheme for civil reform, because I think there's a clear acknowledgement that there is a difficulty. A difficulty has arisen, and that the court system is overwhelmed a little bit, or is ceasing to work very efficiently in relation to oversight of adjudicative decisions. So we actually, interestingly, I think in our report, we don't really mention reforming judicial review at all. We look at reforming appeals, because we see that there is, in the Law Reform Commission, we think there might be scope for reforming appeals to courts to standardise those and to broaden those out, so that a lot more issues would be subsumed into the appeal jurisdiction, leaving the judicial review jurisdiction to do what it does really well in terms of oversight, and to function, the way it used to function, without the risk of duplicate proceedings and spurious or unfounded or mistaken proceedings and actions like that. So that really is the aim of our consultation paper. And the reason we invited you here today was to outline and to explain to you kind of the main topics that we are interested, that we have focused on. But we recognise that you're the experts in the area and we are keen to tap into your expertise. So we're not taking any questions at the end of this session because this is really to stimulate you to think about it and to send in your submissions. And we'd really like your submissions to focus on the areas that you think are most important. And even if that's just for your organisation and it's only one of the issues in our consultation paper, or if it's an issue that we didn't raise in our consultation paper because we're not aware of it, and because we're not on the practical cold face, if you like, just feel free to focus on the issues you think are the most important. And we really are interested in your solutions. We like solution focused submissions. They don't have to be long. They don't have to be complex. They don't have to be, from our point of view, the value they bring are that you're the experts with the practical experience in the area. So there's still no sign of Mr. Justice Clarke. So I'm just going to introduce the speakers. Obviously, we've Miss Justice Bolger, who probably most of you will know, but she was a colleague of mine at the bar for many years, and then she was appointed to the High Court. And in her practice at the bar, Marguerite was often in the judicial review list and looking at employment law cases in the WRC and the Labour Court, and has a huge body of practical experience working with adjudicative bodies, and now is sitting on the other side of the bed with a totally different view of the oversight mechanism. So she has, I think, maybe a pretty unique insight into how both sides of the house work in this conversation. And then Professor Paul Daly, well, Marguerite's going to introduce Professor Paul Daly, but I'll introduce maybe my commissioner, my full-time commissioner, Richard Barrett, who was one of the engineers of this consultation paper and has been working on the topic for many years as well, and is very expert on the topic. And Richard is our full-time commissioner and has been here for 4 years, I think.
Nearly 4 years.
Nearly 4 years, and will be finishing up now in April. So I think it's a great achievement that he's got this difficult and complex and very big consultation paper over the line. And I know that he's going to be following our discussions and our report work very carefully. And I hope we won't be losing his expertise. We're going to continue to tap into it. But I'm going to ask Richard to sit in for Mr. Justice Clarke because I just don't know where he is.
Yes, which unfortunately denies me the opportunity to introduce Frank with the key element of his very distinguished career, that in 1969 he was the junior high jump champion for Dublin. But it was a great pleasure. It is a privilege, and I should say thank you so much to Siobhan for inviting me here this morning. I feel like I've been a long-standing observer or bystander of the work of the Law Reform Commission, and it is a great pleasure to be involved even in the tiniest way in the incredibly important work that we do. I really enjoyed reading the report. As Siobhan said, I spent a long time looking at these adjudicative bodies, particularly WRC, Labour Court, a little bit of the Social Welfare Appeals Tribunal, various other bodies from one angle, and generally, I think, I wouldn't say critical, but a critique sort of position. And now, of course, looking at it from another angle. And I remember actually when I started seeing literally one of my first cases was an asylum case, and I had never done asylum in practice, and it's a little bit off-putting, to do something so new. But at one stage, I had this sort of eureka moment when I asked a very good counsel general, the asylum practitioners are excellent. I said, look, just step back a minute and just bring me through the process. I arrive in the airport, where do I go? What do I do? No such thing, stupid question when you're on the bench. And he talked me through the process. It was like, oh, now I get it. That's the equivalent to the WRC. That's the equivalent to the Labour Court. And it's the same law. So whether you're dealing with Social Welfare Appeals Tribunal, whether you're dealing with the various appeals in terms of special education needs or employment or tax or whatever it is, this is the same underlying legal principles. And it's one of the beauties of being a lawyer that we can slot into whatever it is because we operate by rules, along with obviously that wonderful area of discretion. So Professor Daly has an incredibly impressive academic CV. He is like the good courtman that he is. He is graduate of UCC. He also has an LLM from UCC, an LLM from Pennsylvania, a doctorate from Cambridge, has been part of the law departments in a number of universities: Harvard, Cambridge, Trinity, Montreal, and is currently the University Research Chair in Administrative Law and Governance at the University of Ottawa. He's also a prolific author, I mean, an incredibly long and impressive list of publications, obviously best known in this parish as the co-author of Hogan and Morgan, and it's a particular pleasure to see David Morgan here this morning, both co-author. But I was taken with the fact that one of his achievements is he's the author of a blog, Administrative Law Matters, and that blog has been cited over 190 times by courts in Canada, the UK, Ireland, Australia, New Zealand, and Israel. So it's perhaps an example of the times changing. I was also interested in the fact that he has actually appeared before a number of the courts in Canada, which is quite unusual. It's not something that we tend to see from academics on this side of the water, but something I think that has huge potential. And of course, between 1923 and 1924, he was a scholar in residence for the Law Reform Commission, working on this paper, a very scholarly paper that I think significantly benefits from the comparative law element. And for obvious reasons, there's a particular lean into Ottawa, into the Canadian jurisdictions, but I think it's really interesting when you're looking at identifying problems, both practical problems and perhaps legal problems, and you're looking to identify solutions. And as we all know, work for the lawyers, if solutions could all be perfectly packaged and there was no problem that couldn't be foreseen, we all know that you put something in place and somebody will find some difficulty with it. But that shows up the importance of a comparative approach, highlighting issues, successes, and maybe not such successful issues that have arisen in other jurisdictions. So it's a great benefit, I think, to the work of the Law Reform Commission to have someone of Paul's expertise and prowess, but also his comparative experience, and at the same time, a very real and deep appreciation of the Irish situation. So I'm just going to start with basically just throwing out a few questions just to try and get the discussion going. Firstly, Richard, we might start with you just in an overview, and I suppose it's the reason for the report. But what aspects of non-court adjudication are most in need of reform?
I think, as Siobhan said in her introduction, part of the problem is that the different streams of adjudication by non-court bodies may look perfectly coherent internally to their own stream, but they will go in a different direction from a different statutory body. And sometimes this leads to odd results. If, for instance, there is a judicial decision arising from one context, which then appeals to make a general principle which impacts on other bodies as well. And this can lead to confusion. The outsider might think, or even a practitioner might think, that they deal specifically with one particular body, such as the WRC or some other body which appears to have its own rules, and that seems to work quite well. So they might not identify any major problem at all, as the body they're dealing with has its own rules. But I think for citizens who might deal with different bodies, you need a logic to why there might be different streams of rules attached to different bodies. As is pointed out in the paper, there are sort of three different markets for this topic. There are judges who may have to deal with interesting questions arising from non-court adjudicative bodies. There are the practitioners who interact with all these bodies, and then there are the citizens and applicants and indeed respondents who are expected to engage with some statutory bodies, and the legislative imperative tends to be in recent years that you create a body which is so simple and so accessible that no one needs a lawyer to do it. So we expect individuals to understand the rules of bodies with just by reading the legislation and any guidance that's available. So that is one stream of problem that I think deserves analysis, and it may deserve legislative response, or it might not need legislative response. Some of these issues can be dealt with by clearer conventions, by clearer guidance, by an overall understanding of what the best practice before all such bodies should be. And the other stream is judicial oversight, which is much more techy. And here we have principally the interaction of judicial review and statutory appeals, and even internal appeals, and how these work. And I think a lot of time and energy has been expended on legal issues that maybe could be avoided if we had clear rules on that subject.
Reminds me when I was in practice, whatever about the lawyer's understanding, but for a single client to understand, if you were trying to establish a contract of employment, the classic, are you an employee or a contractor? And the answer was, well, it depended whether you were before the WRC, Labour Court, or the tax appeals commissioners in a tax context, or social welfare, the scope section of social welfare. And to lawyers, you mightn't agree with it, but you can understand, you can be a different thing in different contexts. Try explaining that to Marianne, who just wants to establish her status. So, it's not just a procedural thing, but also a substantive side. Paul, Richard mentioned the potential for, I think he was touching on the potential for inconsistency. Is that something you would have any views on, or is that something you came across, or?
Oh yeah, absolutely. Well, first of all, lovely to be back here. Nicest public sector offices in the country. And of course, my relationship with the Law Reform Commission dates back, I think, to coffee and scones with Richard in Foda Island.
Had to be in Cork.
Well, yeah, the majority Cork panel this morning. And it's been a real privilege to have the opportunity to reflect on some of these questions. And in terms of consistency, I think I would put it in terms primarily of the rule of law and access to justice. The rule of law really suggests to us that similarly situated bodies should do similar things. Similarly situated individuals should be treated similarly. And this sort of multiplicity of procedures that you get can be a barrier to treating people consistently. Difference is fine. We can't be imposing a template across the board which everyone has to fit into, but some level of consistency so that a body which is adjudicating is doing things which are similar to another body which is adjudicating. And I would also put that in access to justice terms. Richard mentioned the citizens who come before these bodies. Justice Bolger mentioned Marianne, who just wants her status determined. And that's very much a part of this as well. Can we simplify and clarify the law so that the ordinary citizen who's coming before a body knows what their rules are going to be, knows what the procedure is, knows what the structure is, knows how he or she is going to be able to establish their rights, their interests, their status. So to me, the rule of law and access to justice are front and center here. And the underlying issue is an underlying issue that exists in every common law jurisdiction that I'm familiar with, that we have had a variety of different issues over the years where legislatures intervene to establish a new body, a tribunal, a regulator, set out rules and principles relating to a particular area. And this is always done in an ad hoc fashion. There's no template, no standard formula for creating these new bodies. And so what we have are a proliferation of abilities across all sorts of sectors of the economy, which are structured differently, with different sets of rules and principles, with different provisions relating to procedure. And that's what causes a rule of law concern. That's what causes an access to justice concern. And what this paper is fundamentally about is responding to those concerns, starting a conversation about how to respond to those concerns.
Just one of the concerns that I was particularly interested in is the idea of sort of legal representation, not so much the right to representation, but how you, and I'm careful with the language I use, you'll forgive me if I'm not quite using, but sort of bring together or, share in some way, say, a body that Richard mentioned, the idea of simplicity and access to justice, and that idea that can sometimes mean doing it without lawyers so that it's available to people. There were quite high statistical sort of aspirations in the report about the number of people who should perhaps be able to appear before these bodies without lawyers. So how do you marry something like, say, social welfare appeals, which is very much built around people appearing on their own? And you can see the way it's built, the way it's structured, as compared to something like IPAT, where it is all lawyer, the Tax Appeals Commissioner, where just in my experience of that is very much as a judge rather than as a practitioner, and maybe it's the nature of the big money cases coming before the High Court. But you've got not just legal representation, but senior counsel, sometimes senior counsel plural. How does that come together in the report's potential view of the future?
Well, legal representation before non-court adjudicative bodies is a very difficult question for exactly the reasons you point out, that sometimes you want informality and expedition. And with all due respect, informality and expedition are not the watchwords of the legal profession. I do some tribunal adjudication myself in Canada, and I always find it hilarious when you have a lawyer on one side for the minister and an individual on the other side, and the different expectations in terms of how long the process will take. The lawyers invariably want weeks and months, and the individual wants it resolved quickly. So that tension is always there, and it's difficult. And I suppose this is one of the challenges that the paper tries to address. It's difficult to strike that balance. You probably don't want to say across the board in all situations legal representation must be permitted. Probably don't want to say that. Nor do you want to say across the board, no lawyers. So what you want is perhaps a baseline, a default, which would be no lawyers, I would say, would be my suggestion, with the tribunal able to make an exception and say that in our particular setting, we will permit legal representation in the following circumstances. But then, we're maybe moving on to the territory of how this would look in legislation. Again, to bring it back to consistency and the perspective of the citizen, if there is an Administrative Procedures Act that the citizen can go and look at, they can see that the default is no legal representation, but that the tribunal may have its own rules. So they know that's the default, and here's where I go if I want to find out more.
And Richard, on that point of the legislation, so the report sets out a couple of options as to what reform might look like, and I think that's very much the area where you're looking for submissions. So the framework statute, can you just maybe give us, as I say to people sometimes in court, give me a thumbnail. I don't want to know everything. Give me a thumbnail. Give us just a very brief account of what the report envisages in terms of the framework statute. What is it, and how it would operate in practice?
Well, in the consultation paper, there's a lot of very good comparative stuff from different jurisdictions, most of which was identified by Paul Daly. And I think the idea is that it is possible to have some overall statutory principles which would be available either for bodies to choose from or for the Oireachtas to choose from, and say there is a list of best practice available in legislation and we will apply some of those rules to this new body, because maybe not all the rules are suitable for everybody, and it would become standard. And over time, maybe some existing bodies would sign up to those rules, or as new bodies are created, they would become the norm across the scheme. And they might be general principles about, for instance, whether to hold a hearing, whether to hold a public hearing, the publicity attached to previous decisions. There are sort of themes that will go through all bodies, and while individual bodies may have a different take on it, I think having a statute which identifies what, as Paul described it, what the default position might be, then the people designing such an agency, or even the agency itself, would be able to say, okay, this is the norm. Is that appropriate for us, or should we have a different version?
And you mentioned the RAC was deciding. I got the impression the report was recommending that the trigger would be from the minister. So it would be the minister would be allowed to trigger what bodies rather than having to amend the parent legislation. Why was that the preferred?
Well, there are literally hundreds of bodies which might, to some extent, be carrying out the function of adjudication. So it would be very disruptive if there was a broad sweep trying to apply new rules to everybody. One of the possibilities is that for existing bodies, there would be a power in the minister to apply, the rules in Annex A of some statute, and that could be done by consultation with individual bodies, and then the minister, either one identified minister for all such bodies, or maybe the minister who is more closely associated with an individual statutory body, would make a rule. And then for new bodies, the principles would be available to the department and the Oireachtas as they were designing legislation.
And Paul, the international experience. So this is obviously aspirational stuff in this jurisdiction. Can you just talk us through what the international experience of the framework statute has been, positives and negatives?
Well, there are a few different ways to do it. You can have a framework statute in relation to procedures, which is what Richard is talking about. And when you do that, you can have a designation model where you have a minister who's saying which bodies, which rules apply. You can also have what the Canadians have, which I call a plug and play model, where the statute will have some sort of a trigger. So for example, adjudication, if the statute would say something like, a body that is engaged in adjudication shall follow these following sets of rules and principles. So you can do it by designation, or you can do it with a statute that has a trigger that would then have to which set of rules and principles would apply. And each of those has its advantages and disadvantages. Designation is perhaps a little bit less obvious from the citizens' perspective. It requires the involvement of the minister on an ongoing basis, but it does lead to clarity when designation has occurred. It's very clear to what bodies a statutory framework applies. The plug and play trigger model is clear in as much as you know that if it's adjudication, then the framework statute will apply, but that may lead to definitional difficulties. Am I engaged in adjudication? Am I not? A regulator, say, Commission Naman, for example, a lot of the time, it's not adjudicating. It's making policies, it's regulating. That's not adjudication. But sometimes it is adjudicating. So when are you falling into the adjudication bucket?
Does the Z word come in there, Zelensky?
Um,
We can't let this go without mentioning Zelensky.
well,
Does that touch on that? Is that part of the thinking there?
well, I mean, I think it was this project predated Supreme Court's decision in Zelensky. And then Zelensky came along, and it would be fair to say that there's a complicating factor, complicating and
Description.
Maybe that's why Frank is. But certainly Zelensky says, well, there is category of the administration of justice. And to the administration of justice, when it occurs in a non-court setting, there are constitutional baselines that you have to respect. And so certainly you would want to have in any framework statute something which speaks to that particular problem, that if you have an administration of justice, you're going to need to follow particularly rigorous procedures. And you are also going to have certain powers. So in terms of receiving evidence and holding hearings in public, these become constitutional requirements. So any framework statute absolutely has to fill those issues.
And one of the things the report mentioned was the idea of a two-tier framework for adjudicative bodies. Can you just maybe just briefly talk us through that?
Well, so conceptually, every statutory decision maker who's determining people's rights and obligations has to act fairly. And what fairness means will differ depending on the context. And so in general terms, the more serious the issues and the more adjudicative in nature the process is going to be, the more rigorous the demands of fairness. And that in and of itself gives you some guidance as to what procedures you can expect from different bodies, though not a whole lot. Framework statutes helpful in laying out what it means to act fairly in an adjudicative context. In terms of the administration of justice, though, so what you have is, we would normally say the duty to act fairly is on a spectrum. So for fairly lax requirements at one end of the spectrum, fairly rigorous requirements at the other end of the spectrum. And what Zelensky really says is that at this end of the spectrum, you're out of duty to act fairly as such, and you're in the administration of justice. And when you're in the administration of justice, you're going to have very particular procedures and powers that you need to have. And the challenge in drafting any sort of framework statute is to take account of that category where you're administering justice, whilst also providing some level of certainty and predictability for the bodies that have to act fairly but are not administering justice.
We'll move on then. The next one was the report talked about the role of an administrative judicial council. So I can bring you in here. I won't bother with the introduction. Frank, everyone knows about his stellar career and of course his current position as president of the Law Reform Commission. The report that suggests in the report is this creation of an administrative justice council. Can you just bring us through what that would involve?
Paul actually knows more about it because there's a Canadian model which is perhaps of some relevance. But I suppose one of the things that always struck me, both as a practitioner and as a judge, was that there was, I don't know what you'd exactly describe, the lack of coherence about exactly how all of these increasingly large number of bodies that are given important roles in deciding cases at first instance, and which often in the European experience might well be dealt with by a first instance court, but we've decided as a matter of policy it goes to bodies like the WC or whatever. But I'm very much also accepting that there isn't a one-size-fits-all model that will work for all of them in exactly the same way, because there's good reason for the differences. But at the same time, I think it's fair to say that there often aren't good reasons for the differences, and there's a certain lack of coherence in the way that they're organized, and therefore an overarching body that could assist in ensuring a greater level of coherence between the various bodies would be a very useful. Also, it could produce models which could operate across a range of different bodies. And I suppose one of the things that often gives rise to litigation is where there's uncertainty about how things are to work, and where different bodies do things in different ways without there necessarily being a very coherent reason why that should be so. That can give rise to litigation, uncertainty. And given that the whole point of conferring jurisdiction in these bodies is to allow them to allow things to be dealt with in a relatively straightforward, local way, where you do create that level of complexity and tension for litigation, you're actually slightly defeating the purpose. So having a body that could not, as it were, impose upon jurisdiction or independence of the various bodies who are given the role of making decisions, but could assist them in ensuring that there was proper coherence about the overall system.
One of the reports seems to envisage quite a tangible role for an administrative judicial council in terms of the composition of bodies. We mentioned the independence of the bodies, and the report seems to be suggesting that if an administrative judicial council had, and I just focus on that in particular because it's a little more tangible than the kind of overview notion of assistance and support, and they're all great stuff, but the idea of actually being involved in the composition of the bodies is more concrete. Can you just talk to us a little bit about what the proposals or the thoughts that the report is putting forward in that context?
Well, I suppose this is the kind of thing we'd very much like to have consultation on, just how intrusive, as it were, the body could be, while retaining the independence of the bodies who have to ultimately make the decision. I mean, it could produce, for example, models that could translate into various different bodies, or options that could be adopted by other bodies. I know there was a discussion just earlier about Zalewski. I've always been of the view that some elements in Zalewski were slightly over-interpreted. While I didn't write the judgment, I was on the court and agreed with it, so I can speak with some little degree of authority on it. I think it's more about the structural edge of these bodies and maintaining their independence. I mean, if you look at the actual issues that were found wanting in Zalewski, it was the lack of security of tenure of the members. It was the inability to public hearings and the transparency that brings with it. It was the absence of the potential of any penalty for false evidence. They were the kind of things that were identified as wanting. And I think an administrative justice council could assist in ensuring that those types of matters were adequately secured across the whole range of non-cultural bodies.
And Paul, how does this operate elsewhere? Again, successes, failures, what's good about how it operates elsewhere? What would you see as perhaps challenges that we might benefit from the negative experiences elsewhere and put in place the perfect situation here?
Well, the primary challenge for administrative justice councils elsewhere in the world is that they tend not to have a very long lifespan, and they have not. The United Kingdom, for example, and in Australia, there were councils. They were energetic, they were useful, but they eventually lapsed for want of funding. So I think it is important to make sure that any administrative justice council is properly locked into any statutory scheme. But what these are about fundamentally are about managing the non-court adjudicative system managing and overseeing things like appointment, renewal of appointments, making sure adjudicators are trained, making sure that this is really about management. In the framework statute, we're talking about access to justice and the rule of law and implementing those concepts. Administrative Justice Council is really about the nitty-gritty of management and ensuring that when the citizen appears before an adjudicator, that adjudicator is independent, is competent, is a fit person to hold the position, has received training on the legal principles they're applying and on how to manage tribunal hearings. They're constantly trained. It's not just they're popped onto a tribunal and it's sink or swim and they kind of learn on the job. They're properly trained and they're kept up to date. And there might also be some sort of performance management that is in place to make sure that the adjudicators are operating properly. There'd be a complaints system, discipline for adjudicators who are not competent or who mistreat citizens who appear before them. These are things that in an ad hoc system, like the one you have at the moment, these are issues that are often left unaddressed entirely, and that is not satisfactory. But you can't have, we shouldn't have, a minister, say, being the one to determine whether a complaint against an adjudicator is founded. You do want some sort, I would say, of arm's length body. And Administrative Justice Councils in other jurisdictions play this role. They are an arm's length body. They're in between, interspersed between the minister and the adjudicator. And that is helpful in terms of securing independence, but also making sure that adjudicators are operating properly. Another aspect to the Administrative Justice Council is, or a potential aspect, is the sharing of services. So sharing of services in relation to human resources, information technology, maybe things as simple as having hearing rooms, being able to pool resources under the umbrella of an Administrative Justice Council could be very useful for adjudicative bodies. So rather than everyone having their own, trying to do everything with their limited resources, there would be some pooling of resources, and one would hope then efficiencies and savings and more effectiveness across the board.
I would move on then to my personal favourite topic, how judicial oversight might be reformed. Frank, can I start with you? You mentioned the various types of appeals that can come before the courts, and I think it was your own decision in Fitzgibbon and the Law Society that is still regularly cited. It's the first port of call in every statutory appeal that comes up. But you've mentioned that already, but I think one of the biggest challenges, I think, that I certainly found in practice was almost like the mastermind specialist topic question was electing between statutory appeal and judicial review. And I now find myself with my judicial hat on. You'll regularly get in a statutory appeal or judicial review the respondent saying this should have been done by way of, more commonly in a judicial review, someone saying this should have been done by way of statutory appeal. But I have seen arguments being made in a statutory appeal that Orange Communication says should be the default. The criticism being made, this should have been done by way of judicial review. So it is a regular theme, and I think it's where you can see the juniors' heart sinking when there's an issue as to whether or not the correct path was chosen, sometimes in circumstances where time is tight and so on and so forth. Can you talk to us a little bit about that and how the report envisages dealing with that knotty area?
Yeah, I suppose this is where it all started, because the reason I think this topic is on the programme for research of the Law Reform Commission was an address I gave to a conference that was called by previous President John Quirke as part of the consultation leading to the adoption of that programme. And I had a rant along the same lines as you just indicated. And I think that's what led to it being there. I absolutely agree that there is no good reason for people having to make this delicate choice between whether it is an appropriate matter for judicial review, as it comes to jurisdiction, or it's something that comes within the ambit of appeal. And there have been some legislative schemes in the recent past that have tried to address that by including in the statutory appeal an entitlement to raise what one might loosely call judicial review type points. And that's perhaps something that we need to consider. Should that apply in all cases? Or why should people be given the difficult task of choosing which is right and which is wrong? If there is to be judicial oversight, it should surely happen in just one stream, one process, where whatever points may legitimately be made can be made. But I think there are other issues in this sphere as well. I mean, what I was trying to do in Fitzgibbon was to try and put some structure on the different types of appeals, because I always felt you frequently found, certainly in older statutes, that it simply said there shall be an appeal to insert name of court without specifying what the type of appeal was. And I remember Peter Kelly, former president of the High Court, saying that it often meant the first 3 or 4 years of any new appeal structure was spent about people debating exactly what kind of appeal was meant by an appeal. Was it a de novo hearing? Was it a very narrow appeal? Whatever. And we had appeals that are described as appeals on a point of law, and certain amount of jurisprudence about that. But I think bringing greater clarity to the types of appeals would also be useful. And also the court to which they're brought. Some appeals are free hearings in the district court and circuit court. Some are appeals in a point of law to the High Court. Now, again, I don't think one size fits all. There may be good reason for having different types of appeals in different cases. But there seems to be a huge variety, and not necessarily very well thought out about why precisely that kind of appeal is the right kind of appeal to have to the courts in that type of case. And there can even be apparently very random differences for which one can't think of any very good reason. I always remember recently retired president of the High Court, Mary Irvine, and as you know, president of the High Court deals with the disciplinary issues from professional disciplinary bodies, making the point that there was a difference in the statute in respect of appeals from, I think, the dental council and the medical council as to the circumstances in which you could introduce new evidence. It's very hard to think of a logical reason why a doctor should have a better chance of introducing new evidence as opposed to a dentist. Now, some of the differences between different models, I think, do make sense and good reason for them, but not all of them. And I think bringing greater coherence to the whole system, perhaps identifying 2 or 3 models, you can pick one of those as appropriate for this type of case, and preventing, in particular, the need for people to choose between bringing 2 different proceedings to essentially refute the same decision of a body, which seems to me to be mad. And indeed, sometimes I think people bring both. If you were that junior worried about which was the right one to pursue, wouldn't you bring both just in case?
Being at a CPD or something, Frank McDonough, highly regarded practitioner of City Council in the area, and absolutely stood over the strategy of bringing both.
And then if someone says, well, you brought the wrong one, you'd say, well, I've also brought this one over here, and that's the right one. But then that's cost, and it's time, money, you know.
Cost is huge, because I mean, my old world of WRC and judicial labour court, judicial reviews, in principle, no costs against the body, whereas the statutory appeal was against the party, and there was a prospect of cost. So that's a very real driver on the ground. And actually, on the cost issue, it reminds me of, you mentioned the regulatory jurisdiction. I remember moving the first application on the Teaching Council Act in front of Peter Kelly. And obviously, as Frank said, the jurisdiction with all of the regulatory bodies, and he would have had the Medical Council list, the Dental Council list. These were all done on a Monday. In particular, professionals, really, the doctors and the dentists had their own list. So I moved the application, first one on Teaching Council, and said, oh my goodness, they're now regulating teachers. You would have to have a Teaching Council list. And I was tempted to say, President, you don't have to worry about that. Teachers don't have the money to. So you can stick with your doctors and your dentists. I wouldn't be holding my breath on the teachers. Paul, the report, as Siobhan said, the focus is not about your focus of the report is really around judicial review. It's about amending the statutory appeals. And the report actually makes various suggestions as to how the system of statutory appeals, which is largely, if I were to fulfill my own brief of a thumbnail, it's an appeal on point of law, generally. Can you just talk us through the suggestions? And again, I presume this is the sort of area where you're looking for submissions. What do you envisage as the possible pathways for amending the statutory appeal?
Well, of course, judicial oversight seems to be an area where reform is in the air, and I don't want to stray outside my remit this morning, but certainly it's fair to say that some of the reforms,
I think that's unfair.
well, no, it's not the judiciary who would be in my crosshairs at the moment. But certainly there's an interest in creative thinking and pushing the boundaries on the legislative side, which is interesting. I think the reform options set out in the consultation paper are fairly targeted, and saying, look, the Oireachtas should really think about standardizing appeals. There are really two options: either have everything as an appeal by way of rehearing. So when the statute says appeal to a court, be it the district court, the circuit court, the high court, it could be a rehearing, a do-over completely. That's one option, and that is very simple, very understandable. The other possibility, which one finds in some of the recent legislation, the Digital Hub Act, for example, is the so-called hybrid appeal, where you would kind of merge judicial review and appellate oversight. And I think there's a lot of attraction to that as well. It speaks directly to the point you're raising about having possibility of judicial review, which is inherent, rights from the common law, and a statutory appeal. One way of dealing with that overlap is to say, well, just you're able to raise anything on appeal that you could raise by way of judicial review. That would then make an adequate alternative remedy to judicial review that you would have to exhaust. So I think that is an attractive solution in terms of dealing with that overlap between appeal and judicial review. But the multiplicity of different types of appeal and different types of body, district court, circuit court, high court, that does make it challenging to achieve any sort of standardization in this area. And so I think the Commission would probably be very interested in hearing people's thoughts on whether these two options are attractive, how they could be actioned, and if they were actioned, what other questions would be left unresolved that might have to be returned to.
And Paul, that brings us beautifully to your role here this morning. The purpose of this morning's meeting, obviously, is to introduce the report to you, but also to invite submissions. I've been asked to really encourage all of you to send in your submissions, obviously with the view to focusing on solutions. There's no need to address everything. I have to say, I did read the report and I really do commend it to you. It is well worth the read, and I have to say it's very accessible in how it's written, which I really like that. So I would encourage you to look at it, but your submissions can focus on as much or as little of it. They don't have to be long. I understand short submissions are fine and even desirable. And if you wish, submissions can be published without the name of the consultees if you don't want your name to be published. So all of that is open to you. I want to acknowledge the work done in preparing this really excellent report, particularly that of the Scholar in Residence of Paul Daly, Coordinating Commissioner Richard Barrett, and also to thank him for stepping in this morning. Research Manager was Siobhan, who was flipped out, Siobhan Coolagon. Principal Legal Researcher for Fiafra O'Coughlin, Quaileen Young and Aoife Enright, and I understand there was also research work done by Eunice Collins, Ivan Ramachikov, Louise Kennedy, Emily Kelly, Ciara O'Brien, and Suzanne Scott. And I'd like particularly to thank on your behalf our speakers this morning, Professor Daly, Clarke, and Richard Barrett, for what I think has been hopefully a stimulating start here today, and most importantly, ending bang on time, so you know you're busy the rest of the day. Thank you.
Should also mention that the Commissioner was actually the coordination commissioner for a good part of the time of this vote got rid.
I hope I'm not too late. I just wanted to say thank you very much to Judge Bolger for coming in this morning and bringing your expertise to bear, brightening up our morning. We're going to brighten up hers, I hope. And this is a very small token to Paul Daly, because Paul worked with us here in the office for a year in close cooperation with lots of the staff. And then he went back to Canada, and we didn't really get to say goodbye to him properly. And this is just a small token of thanks. Not that we're finished with him by any means, but we did want to mark his work on the consultation paper. Thank you, Paul. So we're very grateful to you all for showing up this morning. As I said, we're not inviting any questions. There are copies around if you're interested in our book of commemorative speeches, because we've just celebrated our 50th anniversary and we had some commemorations and we collected together some of the significant speeches. So feel free to take a copy on your way out. But most of all, feel free to send us in your submissions on the reform of non-court adjudicative bodies and appeals to courts. We have recorded this morning's session, so I'll just send you all out an email with the link to the recording so you can show it to your colleagues, and please spread the word, talk to the adjudicators, talk to the lawyers, and get your ideas into us. And the email address will be on the email as well for ease of access. Thank you all so much, and thank you to our panel this morning.